we get started. So we keep the momentum. Francesco managed to get us back on time. We don't want to lose that. Just making sure there's nobody. All right. So I think I don't have to repeat. So Michael Mehling, MIT CEPR, and working with Ivano on the project here from the US, so to speak, to help him, support him while he's based mainly in Europe. And the session or the panel that I'm very pleased to be moderating, even though I'm not an expert myself on the topic, is the procedural aspects of climate litigation. And of course, during the morning sessions and even starting with the keynote, we kept sort of coming across the importance of procedural issues. There's a lot. Christine had a nice slide that sort of showed a number of the different procedural implications or dimensions of climate litigation and also corporate climate litigation. And I don't think we will cover all of them now, but there's two really important topics that we will go into more depth that are absolutely essential for, first of all, any kind of environmental or public interest litigation, and Pilar will take us into that, and that's legal standing and some of the aspects and topics around that. And then we'll focus more on the complexities of climate, this diffuse global challenge that is caused by millions and millions of emitters, and how you can actually establish causality and attribute climate impacts and damages to individual emitters as a basis for litigation. So I'll introduce the panel in sequence, where we'll go from Pilar to Delta to Rodrigo. Pilar Moraga, who I've known now for quite a while, I think 20 years, we just found earlier today. And what connects us is that I'm sort of in heart a Chilean, even though I was born in Germany when I was 4 years old. We traveled and lived in Chile for almost a decade. And so she's like you would say, pioneer of environmental law in Chile, working at Universidad de Chile, sort of the main university in Santiago. She directs the Center for Environmental Law there, and also Center for Climate Science and Resilience. But she's also accompanied many of the legislative developments in Chile as one of the main experts. So she will be, as I said, taking us through some of the legal aspects of the procedural side of climate litigation. Then we'll turn to Delta Merner, who works at the Union of Concerned Scientists, which is a really influential nonprofit organization of scientists primarily, I would assume, although I think there's also lawyers there, but really that provide scientific input. You're the lead scientist for a project or activity initiative within UCS that provides scientific advice and input for legal proceedings and litigation. So it'll be really cool to hear your sort of broader perspective on this topic. And then we'll finally turn to Rodrigo Manrique Garcia from Peru, who's now, you're listed as Universidad Cientifica del Sur, which is a Peruvian university, but you also bring a practitioner's perspective. You've worked as a practitioner for many, many years, are based in London now, work with a large insurance broker. And of course, insurances are one of the private sector sort of sector or subsectors that are extremely exposed to climate change, climate impacts, and also the legal risks around that. So I think we couldn't have a better panel. So many different perspectives, so many long years of expertise, and also different geographic perspectives. And with that, I'll invite Pilar to begin.
Thank you.
Thank you.
Thank you very much. Thank you, Michael. I am honored to be here. Thank you for this invitation. I will start with this topic concerning legal standing in environmental liability for environmental damage in the climate litigation. It's a long title. And I will talk about the Chilean experience. In fact, numerous studies analyze the development and evolution of climate litigation, focusing on its characterization. Nevertheless, today I'd like to present a new perspective, maybe, in particular, how this phenomenon of climate change has unfolded in a small global south country like Chile, home to 18 million inhabitants and highly vulnerable to the effect of climate change. In fact, Chile exhibits 7 of 9 vulnerability characteristics established by the UNFCCC and has an economy dependent on natural resources such as copper and lithium, which are essential for the energy transition and the reduction of fossil fuel use. These characteristics are common in other Latin American countries, like as Brazil or Mexico. Now, from a judicial perspective, since 2013, Chile has a unique feature, the presence of environmental courts, composed of both legal and technical judges. Notably, Chile lacks significant strategic climate litigation, potentially due to the absence of support mechanism for civil society organizations. Furthermore, climate change is not a central element in most Chilean judicial disputes yet. Nevertheless, the climate change element is present in the environmental litigation context, like of Brazil, in environmental courts and higher courts of justice. Most these cases are initiated by civil society or municipalities, addressing environmental harm, the violation of the right to live in a healthy environment, or the right to public participation, generally targeting private companies. When the climate change is present in a dispute, it influences judicial interpretation of legal provision. For example, illegal water extraction may be interpreted differently depending on whether it occurred in an area experiencing water abundance or demand growth. In particular, environmental courts often consider climate change when determining the existence of environmental damage or defining remediation measures. The second environmental court, for instance, we have three courts, one in the north of country, one in the middle, and another in the south. For instance, consistently requires climate change to be factored into court-mandated remediation plans in the damaged environmental cases. Now, this presentation will be focused on analyzing the treatment of legal standing in Chilean environmental damage litigation related to climate change. And for that, I would like to start with a description of the legal framework governing environmental damage liability, and then to continue with the characterization of legal standing in environmental damage liability cases that involve climate change. And finally, I will present a discussion concerning how courts address legal standing in these cases. So, concerning the legal framework for environmental damage, after the 1992 Rio Summit, Chile enacted environmental legislation establishing liability for environmental damage and the right to seek reparation and compensation. According to the law, anyone who causes environmental damage, whether negligently or intentionally, shall be held liable. And environmental damage was defined as any significant loss, diminution, detriment, or impairment to the environment or its components. Now, a legal action for environmental damage can be initiated to repair the environment by natural or legal person who have suffered harm, or municipalities for damage occurring within their jurisdiction. The state represented by the State Defense Council. Now, in the case of municipalities and the state, they are legally presumed to have an interest in the trial outcome. Additionally, municipalities can act independently or upon certain requests. In this matter, it's important to note the creation of environmental courts in 2013, expanded legal standing, promoted greater access to justice, and more effective environmental damage reparation actions. Now, concerning the environmental damage and climate change, we can say that of the 34 environmental damage ruling, 13 reference climate change. In this case, civil society or municipality typically file lawsuits against private companies, including salmon farming and sanitization firms. You can see that in this slide, where there is the plaintiff in three municipalities, NGOs, social society, or individuals, particular, and the state. The last is the state in different tribunals. In the social society are different, for example, farmers, organization farmers, or labor union, workers, union of workers, artisanal fishermen groups. Now, defendants, we can found mining, salmon firms, sanitization sector, thermal power plants, and others. In these cases, climate change is often invoked to justify the existence of significant environmental damage, while defendants sometimes attempt to use it to evade liability. However, courts have consistently rejected climate change as a defense against liability. Now, what is the discussion concerning legal standing in these cases? There are two important cases where defendant challenged the plaintiff legal standing of Tribunal of Valdivia in the south of Chile. The first one is the salmon case, where the municipality of Ancud, Ancud is a, we can say in the map, Ancud is a municipality in the Chiloé island, and in this case, the municipality sued a salmon company for dumping 9,000 tons of dead fish into the sea, contributing to a red tide exacerbated by increased sea temperature. The defendants argued that the municipality lacked standing because the step occurred outside its jurisdiction. However, the court, the Environmental Court of Valdivia, applied a broad interpretation, considering both the physical location of the damage and its environmental impact on the municipality. In another case, the Fishermen's Union sued a coal-fired thermoelectric plant in the south of Chile too, for environmental damage caused by air pollution. The defendant claimed the union had no standing as its member lived outside the immediate impact zone. Nevertheless, in this case, the court recognized the plaintiff's legal standing, emphasizing their direct interest in the cause due to their economic and social ties to the polluted area, because they live and work in this zone. So we can conclude environmental courts in Chile adopt a broad interpretation of legal standing, ensuring greater access to justice in environmental damage cases. Legal standing has proven essential for municipalities and civil society organizations to hold private companies accountable for environmental damage. The Chilean experience highlights the role of specialized environmental courts in strengthening environmental access to justice. So it's interesting experience about legal cases in our country, but maybe we can open the discussion after the panel. Thank you for your attention.
Thank you very much, Pilar. So in a way, sort of the opening gambit in any climate litigation context is, will you have access to judge? Will you have standing? Once you get there, though, the question then is, are the damages that are being claimed, et cetera, is the harm, can it be attributed? Can it be causally connected with the defendant? And so Delta, maybe you can kind of take us through how scientists think about this, especially at a time when science is under so much attack, and UCS is one of the champions keeping up that torch.
Yes, thank you. Thanks so much. I'm really excited to be here today for this conversation and grateful to the organizers for bringing us all together. Looking forward to engaged conversation with this group. And as Michael said today, I'm here to speak specifically about causality. So establishing the causal link requires really a mosaic of evidence, right? It's drawn from multiple disciplines, from historical documentation, from internal communications, economic modeling, engineering assessments, community testimony. All of this contributes to the essential pieces of this puzzle, right? Each of these lines of evidence plays a really vital role in presenting a compelling case. I don't have time to talk about all of these lines of evidence today, so today I'm going to focus in particularly on attribution science. This is a body of research that allows us to quantify how much a particular climate impact, such as a deadly heat wave or devastating flooding or rising sea level rise, can be traced back to human influence, and increasingly to specific sources like major fossil fuel producers. Attribution science doesn't replace other forms of evidence. I want to be really clear about that as I'm speaking today, but it enhances and complements them. So by providing a rigorous scientific basis for linking emissions to observed harms, it helps to fill a really crucial gap in establishing responsibility in the warming world that we're all living in today. So today, my plan is to walk through how this science works, where it's most robust scientifically, and also in the legal context. All right, so what is attribution science? Attribution science is a really rapidly advancing field, and it helps us to understand the influence of climate change across a range of different factors. So from long-term shifts in climate patterns to the role of climate change in altering specific events. It can also be used to analyze source of emissions, so allowing us to understand how those emissions contribute to climate impacts. By analyzing data, models, observations, attribution science shows us how climate change has altered everything from temperature trends to extreme weather events. It helps to distinguish between natural variability and human influence, helping to answer really critical questions like, did climate change play a role in this event, or what emission sources are contributing to climate change? So kind of in short, attribution science can explain how climate change makes a heat wave hotter or a hurricane-related downpour more intense, as well as quantify how emissions from specific sources contribute to climate impacts. All right, to dig in a little bit further, I want to break it down kind of briefly. So when often when we talk about attribution science, we kind of use this overall header, but there's 4 important subfields that I want to just mention to provide kind of some specifics on what the field really looks like. So the first is trend attribution, and this is science that's identifying patterns of change over time. The second is event attribution, and this is probably the most well-known area. And when people hear attribution science, this is probably what you're thinking about. This examines specific extreme weather events, such as particular hurricanes, a particular heat wave, or a flood, and asks how climate change has altered that event. There's also source attribution. Source attribution determines the relative contribution of different emission sources, such as fossil fuel industry or the agriculture sector, or even a specific country, to the overall rise of heat trapping gases in the atmosphere. And then finally, there is impact attribution, which is the newest area of study. And this looks at how climate change is affecting ecosystems, economies, communities, kind of what those overall impacts really are. Altogether, attribution science can help us understand not only what is happening, but also why and who or what contributed, right? So this is important to note because these subfields are slightly different. They're asking different questions. They're using some slightly different methods, providing different answers. But kind of regardless of the subfield, what's important to know is that attribution science is a powerful tool in this space because it moves beyond correlation, and it offers a way to establish causation between climate change and climate impacts. So I want to dig into a little bit of how this actually works, right? So what attribution science is really doing at the heart of it is it's comparing 2 different scenarios. So it's looking at the world as it is today with current greenhouse gas levels compared against a world, what's called a counterfactual world, where we can say, what would have happened if those emissions hadn't occurred? You know, what does the world look like without those emissions? So really what attribution science is doing is it's comparing these 2 different models against each other. I wanted to kind of demonstrate this in one figure from a paper. So illustrated here, this shows how attribution science works by comparing, real world model to counterfactual models, those models with the additional emissions. So just to explain a little bit of what you're looking at here, on the left-hand side, you have a graph that shows the observed and modeled global sea level rise. So this is what the sea level rise actually looks like today, human-caused sea level rise from climate change. In the center, we have that counterfactual. So this is the model that's been run over and over again to really show what would have happened if we didn't have those added emissions. So where would our sea level rise have been without those additional emissions? And then very simply, the third kind of panel here is looking at the difference between those 2. So it's saying, all right, we have these 2 different worlds. What's that difference? And this is how we really get at attribution. And we're saying, again, like what's the variation between these? This side-by-side approach is core to attribution science. It quantifies how much worse climate outcomes have become due to carbon emissions by asking, again, what if we hadn't warmed the planet, essentially, right? That's what it allows us to do. This slide, for time, I'm just going to mention really quick. This is just another kind of representation of the same idea of what the modeled world looks like compared to the existing world, and can show kind of some of the statistical differences that we see for the potential for events to happen. So if there's more questions, we can come back to this, but I wanted to, but again, this is just kind of another representation of the same idea. So now that we've seen how attribution science works, the next question is, what are we actually applying it to? So this is a graphic from the IPCC 6th assessment report that summarizes what the science now clearly shows, right? So climate change is making extreme weather events more frequent and more intense. We see that there's more extreme heat, there's longer, deadlier heat waves, that heavier rainfall events are happening more often, increasing flooding risk. Drought is becoming more severe in some regions. Fire weather, the hot, dry, windy conditions that fuel wildfires are on the rise. And our oceans are not only warming, but they're acidifying, they're losing oxygen, and this is damaging marine life in coastal communities. These are not general trends anymore, right? Attribution science is helping us connect specific events, again, like these deadly floods or record-breaking heat waves, to human-caused emissions, often with very high confidence. And again, that's what makes this science so powerful in legal and regulatory settings. One of the things that I wanted to note with this slide is that it's important to kind of understand the inclusion of attribution science in the IPCC sixth assessment report. This marks a real turning point in the evolution of this science and of its acceptance. So what was once a developing field is now recognized as a critical part of climate science, rigorously peer-reviewed, methodologically sound, and broadly endorsed by the scientific community. This I'm just going to show really quickly. I wanted to show the range of attribution studies and variations in the findings. So this chart is pulled from Nature. It's specifically looking at 170 peer-reviewed studies, and it's showing those broken down by different types of events. And in the colors here, you can see where the studies show that there's been more severe or more likely, the event is more likely to occur because of climate change. You know, there's some purple occasionally where it's less severe or less likely to occur. And there's blue, there's still areas where we don't have enough data or where we don't see an influence of human, any discernible human influence on that event. And I wanted to show this for transparency. And I also think that in a lot of ways, this really strengthens the science, right? There is variation that exists within it. And we can see that when we look through the literature. That being said, it's also important to note that attribution science isn't equally advanced for all types of events, right? So the strengths of science varies based on the type of an event, the region, the availability of data, the maturity of the methods used to model the different types of events. So here, these are two kind of variations of the same figure that are about a decade apart. So on the left here, you see a figure from 2016 that is looking again at the confidence of attribution science. So about a decade ago, events like extreme heat were already highly attributable to climate change, while events like severe storms or tropical cyclones, they were harder to link with confidence. In panel B here, you see the increases in just over a decade, right? So it shows how much the field has progressed. And today we have robust evidence, not just kind of around terrestrial heat waves, but also marine heat waves, extreme rainfall, different types of drought events. Again, just to kind of show that overall relationship and the progress that we've seen in the field. Now, science is shifting to not just be able to look at climate change resulting from human-caused greenhouse gas emissions. Science is also able to attribute changes to specific emissions of sources. So here I'm showing a graph in blue of the global carbon emissions from all fossil fuel producers and cement manufacturers since 1850. This is in millions of tons. In red, you see the emissions from just the top 90 producers. This is work that was published by Rick Heady. Overall, what this is saying, or the study here found, was that 2/3 of all industrial carbon emissions starting from the Industrial Revolution onward can be traced to 90 carbon producers. This research has been updated and continues to grow. So Influence Map now holds it. There's over 122 companies that are involved, but I wanted to show this graph, one, because a lot of the initial studies on source attribution are based on this data. And also this study is very well cited in the toolkit from BIICL. All right, so before I jump into source attribution, I want to say kind of why we're looking at it. So source attribution is really important to make clear the causal chain kind of in these cases, right? So what we're really looking at to be able to attribute for attribution to industrial polluters is looking at kind of the causal chain of evidence. So you have fossil fuel production by companies that leads to increased greenhouse gas concentration in the atmosphere, which causes higher global temperatures, which then drive extreme events and damages that we've been discussing. So again, this is kind of the legal framework that is really important, kind of this chain for understanding these studies. So quickly, I'm just gonna mention a few studies, source attribution studies over time. This first one was done by my colleague, Brenda Eckwurzel, who worked to run kind of simple climate models to look at those emission data, calculate the average temperature, global surface temperature, and sea level rise tied to emissions from those 90 producers. Here she found that from those 90 producers, that, between 42 and 50% of global temperature rise can be attributed to just those 90 companies. Similarly, for sea level rise at the time, 26 to 32%. Again, total global sea level rise connected to just those 90 companies. There's since been a study on ocean acidification where we see more than half of ocean acidification tied to those same carbon producers. This is a graph that's actually from the appendix of that study, just to pull out the specific actors. So here you can see, again, why this type of science is so important is because you can actually look at the individual companies, you can look at their contributions and the role that that actually plays in the overall piece. So this is something that is published alongside that research. One of a more recent study that I was a co-author on looked at wildfire weather. And here we can see that 37% of forest area burned in Western North America and Western Canada since 1986 can be attributed to these companies. And then the most recent study, this is a study that was published just a couple of weeks ago that I'm a co-author on. Here, what's interesting about this study, what's new here, is that we don't just look at the contributions of emissions of sea level rise up in today to today. We looked at how past emissions from fossil fuel companies will shape sea level rise into the future. So looking into some of those questions, the legal questions around future generations, some of those pieces. But we also modeled counterfactual scenarios to say, what if emissions had been reduced at different points in time? So if they hadn't come, which is what a lot of these cases look at, but also what if the emissions had started to reduce at the point when industry knew about climate change based on the historical research? Or what if we actually started to reduce when the global climate negotiations started, right? What's the difference that we see in the world today? So again, these are research questions that I think are really informed in the legal context. So for time, I think I just want to talk a little bit, again, kind of driving this home. Attribution science is powerful, but it does have some limitations. Again, we have to be really specific about the actual question that we're asking. Attribution science isn't going to tell you that an event was 100% caused by climate change. That's not how it works, but it does help you to understand the role of climate change in altering an event. And that's really where the science lies. Attribution science plays a role kind of across the evidentiary chain that we have. So from source attribution, helping us to understand who emitted what and when. Global change attribution shows us how those emissions altered the climate system. Impact attribution explores how climate change affects physical and social systems. And then extreme event attribution quantifies how specific events have become more likely or more severe due to climate change. It's all of these pieces together that kind of help us to build this evidentiary chain and help us to get at these overall questions that we're asking today. So with that, there's my contact if there's additional questions, and look forward to conversation. Thank you.
Wonderful. It was fascinating. I'm sure it'll also spark a lot of questions.
Sure. Sorry.
And from what I understood and seeing briefly Rodrigo's presentation, you'll kind of zero in a little bit and give us a more specific example of, you had some that you're
Sorry,
not
those
going
were
to-
like the
not at
question
all.
slides.
Absolutely.
Well, thank you very much for the opportunity. And well, after those presentations, it's going to be really hard now. So I would like to come a bit. I feel that it's really important also to bring different voices to the table. So I'm going to lean into my perspective from a Peruvian practitioner and also from a Peruvian perspective, but basically on the evidentiary challenges and the burden of proof from this context. So for that, I'm going to focus on context and people to understand where it's coming from. So 1970, we had a slide in the Andes. There was an earthquake that produced a slide from the Cordillera Blanca that landed into a lake. That lake overflowed and created a huge slide that killed, that says 30,000, but that was after the weekend when they went there, actually ended up in 60,000 people, which is the most deadly earthquake in the global south. It's the deadliest earthquake in Peru, and it completely destroyed several towns, including Yungay, where you're going to see it here. So with this mining context, that there is evidence, even from the 70s, the impact would be different without climate change. But nonetheless, this is where it's these circumstances about slides in this situation. So saying that, 45 years later, Santiago Luciano Yuya, it's impossible to be Peruvian and not talking about climate litigation without talking and engaging in Saul, which is, he's a rock star. I really admire him. So he's a farmer and a guide, mountain guide in Huaraz, which is kind of like the same zone. And he contacted some people from German Watch after they went to COP in Peru, and they were talking about, and he was very knowledgeable about floods, risk, and he was really concerned because they have this situation on the back of their mind. And they said, but you know, Saul, this is increased because of WRE and the polluters and the climate science attribution. Would you like to be part of this thing that we're thinking about? And they were all in 10 years ago, and everybody was thinking these guys are crazy. Like the thing that they're trying to get into the court, there is no way on earth that will go fly. So in a nutshell, they were basing the case in a nuisance case in Germany. They were going against one of the biggest emitters in the world. I'm not going to say the name, so I just want to stick to RWE. So in a nutshell, the case, what it's trying to say is that due climate change, it will increase the risk of slides on the Cordillera Blanca, continuing the circumstances that they're coming. And then on the other hand, RWE is clearly responsible of some part of this CO2 emitted in the atmosphere. Those circumstances create higher risk. And then, therefore, the government of Huaraz and also Saul will have to go for further costs to create defenses to this flood. So, therefore, RWE should be taking the bill according relatively to their responsibility to the CO2 emitted. Very linear, very sophisticated, very fascinating train of thought that everybody thought they were completely impossible to win. So we'll see. I will go back after that. Starting my career as litigation, I clearly understand why Amaru is that face. He's trying to put the numbers on every page when you do litigation in Peru. So it's that's a very complicated issue going through litigation. He's not happy, however, Amaru Alvarez and against some other people. Emilia, she's very happy with the outcome of this lawsuit. And these guys, there were 7 kids who filed a lawsuit against the government of Peru, engaging because they feel that they failure to formulate and implement a national public to reduce deforestation in the Amazon. And then therefore, without the action of the government, they will be increasing the risk of their livelihood. This is also connected to deforestation. So even though I'm bringing cases against the government, there is an implication and there is a connection with corporate activity. Sadly, in first instance, the government, the judge ruled against this case, mainly due to the fact that they feel that the government has not provided enough evidence to comply, that the policy did not provide exact actions for the government to protect the Amazon, and also because the separation of powers, and there is not the role of the court to impose policy, which is common situation. There is also 7 cases brought by, okay, you can see that, I cannot see the big. So Yanua is the president of an organization that she, as a representative of the community in the jungle, they are a representation that goes on environmental policies. So they brought court to Peru of many circumstances, and they brought seven actions against the government to comply with the laws of the national climate change laws. There was a specific point where the government had to implement investment in renewable energy, research, ecosystem services, development and innovation, and they haven't done it. So they just brought the court to Peruvian court, and they failed on 5. The government saw that there were not enough action from there to increase the government pressure, but they were successful in 2. And finally, the other case that I wanted to bring is the broader participation of the advisory opinion of the Inter-American Court of Human Rights, and how that has this galvanized Latin America and in general America against bringing this point to the court about the actions of the governments in relation to protecting from a human rights perspective. So in this case, there was an amicus curiae from the universities, including Universidad Cientifica del Sur, and then there was the participation. They decided that the people who were going to speak on that event was going to be a student. So I just wanted to bring, not going deep into the cases, but I feel that this is going to set the case for understanding from the perspective of litigation, from a global South perspective. So two things about, only so far you realize all the people who bring in this case into the court are people who have not only the disadvantage from this global South, global North perspective, that they have to, go against the giant, but also there are the communities who bear the cost of the climate change. So indigenous communities, youth, campesinos, and it brings how these circumstances, even though they have those challenges, they've been able to bring these cases to court, and they have huge challenges, including and mainly evidence and burden of proof. There is a variety of circumstances and avenues that this can happen, and I feel that it's important to acknowledge that there are many circumstances where these can continue on the path based on, theoretically, these legal avenues that these cases are opening. So we're looking, for example, subnational levels from the global South against fossil fuel majors. We have the case from, for example, many municipalities and states in the US for this case, but it can be replicated to the relevance and the actions of these companies in the global South. There is civil society from the global South against fossil majors in their country or in the global North. Again, the challenge there will be the possibilities, the actions, and the proof that they will have to bring to the court. There is also the governments, which is the global South as a government. In this case of Saul, part of the money that it will go for the defense will be paid by the municipality of Juarez. So Juarez can be part of this lawsuit. Is there a chance? Is there a case where subnational and vulnerable states can bring action and justice to these to courts? And there are different approaches, different perspectives of reviewing this case. But we're gonna go back to Saul because I feel that it's very relevant to understand a bit the connection and the case, specifically about the evidence. So the case started with what we saw, but it was dismissed on the first instance, mainly because the judge in first instance did not consider that there was a linear cause link, because the participation of WRE, it was not enough to be liable for the whole climate change. And the other point is, even if it was part of this, it wouldn't change. So even if you accept that I really was responsible, even taking that in consideration, it will change nothing in Saul's case. There was an appeal, and the higher court of Ham brought in 2017, which I believe it's going to be it could be the relevant arguments for the climate litigation in the future. So the first one is that it overturned the first instance and accepted the case to go to evidentiary phase. It was the idea that it has to be set in court scientifically to prove that the position that it was brought to the case. So there was an increase in expansion of volume of the lake. So if that will lead into an increased risk, if RWE emits CO2 to the atmosphere, and then it was climate change a thing, like, believe it or not, that was part of what we need to prove in this moment. And if the temperatures in Juarez are increasing due to climate change, and then therefore will increase melting in the glacier, and what was the proportion of the responsibility of WE in these costs that were in 2018, after there was a big win, where I feel that, again, the second stage of things that we can build from here are, first of all, the climate modeling is acceptable as a source of legal evidence. So now this is the first case in that we can understand that everything that Delta has been brought to our attention can be brought into court as a legal evidence. So even if it sounds silly in this room, it was great that it was accepted by a judge. And also, even partial causation cannot be excluded from WE, even if it's not 100% responsible. He's responsible in some extent. And finally, going from this extrajudicial and this and the connection with this global jurisdiction related to human rights, it's about how a company can be liable for their actions, not only in their state, but also globally, from this global neighborhood concept. There was a delay on the process, that's why it's 10 years. And there was a cite to whereas by the judge and the experts that they were appointed. And last week, there was the first stage of the evidentiary phase in Germany. Saul came with his lawyers and their scientists to brought to this case. And I feel that There was an improvement, there was a movement on the case. However, there is a bad point from this perspective, that when we say about science, there is science and there is science. So the experts that were addressed by the court, they were not experts in climate change. So their outcome, formally the outcome of this evaluation has realized that the increased risk of Saul circumstances direct link to climate change are valued at 1% of risk, and without acknowledging the fact of permafrost and also rock bouldering, which was the issue that brought whereas in the first instance. So even not acknowledging historical facts. If you consider those circumstances, then the risk will go to 30%. So now the question in this stage, at this day, is if 1% increased risk of the livelihood of a community is a bearable risk as a society. So some consider that 1% could be part of a risk of a human activity, and therefore there is no responsibility for a corporate actor. One consider that yes, no matter what we're speaking about human lives, and then if you think about 1% risk of the flying of a flight going down, will you take that flight? So we'll see. So there is not everything good in this case, but I feel that it has opened the door to major circumstances. And now I feel that this is a discussion about where we sit now with everything that we have discussed. So there is many layers of evidence that we need to talk about, as Delta was bringing to the attention. And mainly it has to be rely on sources. So from the emission perspective, I feel that's the stage where with science and there is less contingency about understanding where the CO2 comes from, who are the responsibles, what have been doing it, what's the amount of CO2 in the government. So this is based on two major papers, so Carbon Major Report, which has been updated, and also the consideration of the IPCC assessment report. I feel there is a lot of evidence, and it's getting to the point that non-discussion about who are the responsibles and what's their responsibility in the fact of climate change. Now, the point, I also feel that from the evidentiary report, it's good to bring back to the attention that some circumstances, it sounds complicated to prove to the court, and even if you lose 100 times, eventually it will change. So when we're talking about the piercing of the corporate veil, for example, the circumstances where corporations used to build a corporate structure in the global north to avoid responsibility, that's an 80s idea about how the world is. Now, every time there is an increased appetite from the courts to open the discussion at the very least. And I feel that we should keep pushing that agenda. Also, I was speaking with Daniel about burden of the proof in Brazil. So for many years, they've been bringing that point to the court, and they were losing again and again until they're not. So it's a matter of using this legal evidence and these circumstances from across the globe to improve legal arguments to the courts, and eventually it will come. Peru also is being positioned up front, for example, on the rights of nature. There is also cases from the rights of the Marañón River as an entity, and therefore what is the responsibility, the government and society to protecting it, and then what will give standing to several organizations to defend that river. You could do the same argument for glaciers, or you can do the same argument for sea level or the ocean. And also the notion of extraterritorial justice and extraterritorial jurisdiction, which this is one of the cases that has been brought to the attention from the European perspective, and it can bring the case to US attention. So also there is the point about understanding how sophisticated tools from risk modeling have been improving during the years. The science is moving forward, and it's getting more sophisticated and bringing more attention and more data to climate litigators to use this not only from the attribution science, but also from the specific risk. And I feel that it can lean into the theory and the data and the tools that the insurance world has come to can provide. And that lands to the next thing. So when we're talking about these big challenges and about specifically from the global south, what can we do? So I feel that is cooperation. We need to build these contributions. We need to build this community. We need to build connections and try to understand how this litigation is not an isolated issue. I mean, coming back to Saul case, it wouldn't happen if they wouldn't met in a hike with the German guys in Whereas, which, I mean, it's kind of obvious that, of course, they're German. That's what they do. So, but it proves the point that cooperation is the way that we can overcome these challenges. And I wanted to bring a case about this. So The Imperial College of London has a storm model that is called IRIS. It's a statistical thermodynamic model. So what the idea is they have been doing is to understand, and I'm bringing this case, you can understand from the context of community, of why it's important. So they're isolating all the information, and they're only focusing on the end game, the power of the storms, where they hit the land, where the risk and the damages of human people. So they're isolating the information, and they're doing not only with the statistical data, but also understanding thermodynamics. So again, I'm just bringing some ideas from Delta to a specific case. They're doing from a global perspective, and they're trying to understand the maximum intensity and the potential intensity of storms with this idea. The collaboration is because it's based with the information, tools, and knowledge from the insurance world, and also from universities across the globe. They're doing it in a way that no one can be able to hijack this information. They want it to be as broad as possible, so they don't have this conflict of interest concept, but the idea is to be universal and uncontroversial, to be useful from this loss and damage perspective. So what they have done is track the storms from global storms from 1980 to understand what is the behavior of the storm, just from the perspective of the last impact. And they also have been studying thermodynamics in the tropical to understand what could be the effects of the weather and the heat in storms. They have isolated the power of the storms on the specific location. You can see the power and the velocity of the wind that decay when it hits the land. And again, what they have done is validated with reality, what we were saying. So they have used these models, the theory that they're creating, comparing with all the storms that they have reviewed in the US. So what they have and agree, there is, if you see the lines, the observation is the reality, what has happened. IRIS 1980 is the model that would be without actually climate change. And IRIS 2022 is what happened with climate change. And then you can see how the storms will go from 1 in 30 years, it go with 1 in 10 years. So the intensity is bigger, it's easier to get this quality of storms, and then also the speed. And then you can use this with 2 degrees world, so you can calibrate what will be the world, and then you can use it specifically on storms. So they have done it with Haiyan, for example, where you can see what is the power of the storm with climate change. And then when you have this calculation, you can also calculate the cost, because you have the data where Haiyan was doing in the coastlines. The same with the hurricane berries. And the idea is, if you see the angle, again, without climate change, maybe there will be that storm, but it will be less often or less powerful. And so if you can isolate that data and then you can compare the costs, then you have the case to understand who is responsible, and then you can go for, well, that's the idea. Well, thank you very much. Happy to have any questions from you.
Excellent. Thank you. I think this was like a menu that was really structured one on top of the other, and great narrative. I'll open it to the audience right away. I have questions, but you have precedence. Attendees online, of course, as well, and here in the room. Any questions to Pilar, Delta, or Rodrigo? Yes, please, Bernard.
Okay, so nobody else wants to ask, well, I'll ask.
Thank you.
So first question to Pilar, and that is, how did these environmental reports come about? You know, what sort of drove them? And again, you know, for me, it's all about lessons. Are there other jurisdictions that can learn from Chile's experience to create such innovative courts? That's question number one. And then I think the question is really for the two of you. So I was amazed by this idea that you can really pinpoint through attribution science, like how, I guess the increased propensity for a corporation to have created climate change. Is this science, is it like refutable? Like, is it, you know, how concrete is it? You know, and if it is really strong, you know, why aren't we using this to go after more corporations? And, you know, is that factoring into the Saúl case? Are they using, like, I don't know exactly how this works. Like, Delta, are you like the world leading expert on this kind of stuff? Or are there like a whole bunch of scientists around the world that are doing this? Or I guess.
So the environmental court were created in 2013, and these tribunals know the environmental damage request, but the administrative decision. So the tribunals review the administrative decision, for example, environmental assessment or control decisions, sanctions, or another in environmental law context. And the climate change was introduced by the defendant, plaintiff, or judge. So in different cases. I don't know if I answer your question or we know a specific.
I guess the court itself as a structure.
The structure.
Yeah.
So it's the 3 judge, one technical judge. We have 3 tribunals, one in the north, another in the center, and another in the south. The jurisdiction is north, middle region, and south. And the structure, it has 2 lawyers, judge, and 1 technical judge in each tribunal. So this is the structure. And there are the technical professional who support decision, or they prepare report to decisions, for example. But this is the structure.
Yes, before we get to the second question, which is also a big one, but there are other countries that have environmental courts, right? Anybody in the room that can just, that would be for which country?
There are many, there's actually 2 reports that have been done that go through and describe the various courts, but
Mhm.
the last number I remember was
Brazil, right?
350 some odd.
Kenya.
Kenya.
India also,
was-
yeah. Very
Got it.
obvious.
Costa Rica.
Look
Costa
up
Rica.
the cranes, are the ones that done categorization types of courts.
Okay, so something I'd also like to look at more. How has it improved decision making, having the technical and legal expertise? Now to the second question about the attribution, the precision.
Yeah, so one of the reasons, so I guess to start, something that's important is that there's different scientific communities working on those different subfields, right? So for event attribution and the type of work that Rodrigo presented, there's a much larger community that's working on event attribution. And that work is incredibly strong and incredibly rigorous. And that's really what you see cited in the IPCC. That also trend attribution, I would say, both of those are very well established. For the source attribution, the opinion, that's a much smaller group. So we are one of maybe 3 research groups that are doing that. We're the first to be publishing in this area, and again, one of the few. It's some of the limitations that are important to understand is one that, it's coming off of, all of this is really based off of the data set from HEDI, right? So we have a single data source. And with anything, right, when you have a single source, you can then go after that source, which is something that can be, it's a strength and a weakness. That source of data is really coming from the companies. It's from their own reporting of emissions, generally to their shareholders on what they have sold. That's how a lot of those emissions historically have been calculated. But that also means moving forward that the companies control a lot of that data, which is really important to understand. And there's a lot of black boxes that exist around understanding that data. So I think that's one piece that's really important to understand about it. The other piece is, I showed that one graph with the different companies, and even the largest producers that you're looking at, that was for ocean acidification, and it's going to look slightly different for different types of events because emissions, it's not a consistent relationship depending on different impacts. But the biggest contributors there, you're talking about 3.5%, right? So if you're going after single companies, right, you're talking about small margins, and that's where you get into some of the things that Saul is dealing with, where if you have a company that's 1% or less than 1% of that total emission picture, what does that look like in the courts? And does that fall often? It might fall within the margin of error. And then how do you talk about that? So that's something I think like in the US litigation, which again is not emissions litigation, but you often see it brought against several companies, right? And those numbers look different, and it can be tricky when you're looking at individual companies. And we see that with the E&I case in Italy, some of those things, right, of how you address those issues. The other piece that's important to understand is that the HEDI data set is including scope 3. And the courts, we've had strong wins to include scope 3, but I think the debate in court that the companies would bring up is whether or not you include scope 3. If you don't, then these numbers look really different. So again, I think we have scientific and legal reason to include scope 3. I don't think that's a debate, but that is something that would come up in the courtroom for sure with this type of research.
Do you want to add something?
Yeah, I mean, from a litigation perspective, this Irish case is linked and supported by insurance brokers and US litigation law firms. So there is a real interest on that. Moody is creating a model about climate litigation liability modeling for reinsurance from a legal perspective. So even though it's not massively available, it's brewing there, like the idea that eventually, mainly because of the circumstance of the litigation from this strategic perspective, eventually when determined cases will go, then it will ramp up, basically following the model of asbestos litigation or tobacco litigation, which also leads to the question that you were saying, that science can be challenged. And yes, there will be challenge, and the defendants will have models that said completely the opposite. So that's the world that we live. But and also in this context, as we know that now science can be challenged because for different reasons, political reasons, let's say. But yes, so there is a challenge, but I mean, at the end, the idea is that the more and the bigger and the better, the argument will win on its own. So I feel that we're aiming the right direction. I hope.
We have to hope that facts or scientific observation.
Sorry, there is a.
Can I add one?
Yes, of course, of course.
Yeah, so I just wanted to sort of call attention to, I know I mentioned the climate judiciary project to everybody at the beginning of the day. We just published last week sort of a primer on attribution science that I think would be really useful for everybody, on the idea that there's been a ton of climate science attribution studies published in the last couple of years. And so one of my colleagues sort of went through and talked about all of those, and I'm sort of drawing your attention to that. We also published a module on climate litigation in Europe that talks about the UE versus RWE case. So if you're interested in that. And last point I want to make is just from the litigation perspective. I know there's, you know, your question about like, why don't we just sort of use these tools if they exist? And there's literature out there to suggest that, you know, lawsuits are not incorporating the state-of-the-art science a lot of times. And so I do think there's a study on the evidentiary gap that exists in litigation between consensus studies and some of the state-of-the-art stuff. And so I do think there is some room for what's being used.
And the publication or the primer you mentioned is on the website, ELI's
On the
website?
website,
Okay,
yep,
great.
cjp.eli.org.
Perfect. Thanks for that
You're welcome.
addition. So any further questions? And again, I'm mindful that there might be some online.
Yeah.
Do we have some already? A very specific one. Is it okay if I take one or two from online while our in-person audience collects further questions if they have any? So there was one from, it doesn't matter, I'm done, but a greenwashing case in Brazil initiated by IDEC against Go, which is an airline, and Localiza, which I don't know. But I don't know if there's a question there.
Yeah, I feel that.
It's more like a comment, you know?
Yeah.
Yes, please, Amelia.
So this was really great, interesting. Thank you. This question kind of gets at, while we're talking about gaps, the space between standing and attribution science, which I see as attribution science having a level of scale, and then like a broader scale, and then have to get into court sometimes, bring it down to a very local focus to support standing. And so sort of what are your thoughts about connecting those dots, how the science is developing to help do that? And then the flip side would be, do you see value in, or are you aware of efforts to empower communities to recognize climate impacts that are happening to them as climate impacts, or sort of training communities to recognize and include those from the ground up to bridge the gaps between sort of the very sophisticated, complex science and the experience. And I guess the German case is an example of bridging those areas, but I would, litigation perspective, see that as an area of ongoing development in the law right now. So I'm interested to hear your thoughts. Whoever wants it, sure.
Like to-
Ladies first.
So the environmental court in Chile considers science a little bit. So for the environmental tribunals, the climate change, for example, is an evidence. So they assume the climate change exists. So, and sometimes in some cases, the tribunals said that it's an evidence the climate change is here. So after that, sometimes, for example, in a case where a mining company work in the mountains and affect a glacier, the tribunal compares this glacier with another glacier outside in the zone affected by the mining company activities. And this methodology conclude that both glaciers are small than before. So it's climate change. It's not the mining activity. So, but the tribunal don't consider all evidence existing in Chile. So we start to consider that, but not a lot.
That's good.
Yeah, so to the scale question, so it's true, the majority of the source attribution that exists is at the global scale and is looking at global data. The wildfire study, their wildfire weather study that we published was the first one to do regional downscaling. So to be able to take some of those models and look at a specific region. But again, that's not, we're not looking at a specific city or a specific community. But so the science is advancing to get more local. Alongside that, though, I think it's really important that we're asking questions about what science is really needed for these courts, right? So we can't expect there to be a local study for every single event that happens. And I don't think that we need there to be. So different jurisdictions and different courts require different standards of evidence. And we really have to ask, like, what's the least amount of science that's needed to answer the questions that those courts need. And often, I think kind of the global scale, at least on the source attribution side, should really cover what is needed for a lot of those questions. That's different on the event attribution side, and event attribution can be much more local, and as well as impact. So we already have studies that show in the US at a census scale what economic costs of flooding from sea level rise have been. Again, this is something that we create data disparities though, right? This is something that is possible in places like the US, and it's not possible in places where you have data gaps or you don't have that data available to model those things. So we also have to be really careful about how localized we get the science in some ways and make sure that we're not limiting courts in other areas because there's a new standard of evidence that's being required by courts, right? So I didn't say that very eloquently, but I hope you get the idea there. So I think there's really important play between the two communities that we need to be talking about in that space.
Yeah, also regarding the communities that you brought the point, I feel that, I mean, there is a sense, in reality, communities have more knowledge that we as a Western acknowledge, like the communities that live in the jungle, they really understand weather, and then they know that the climate change is a thing. So it's not that we need to go then and explain to them. It's a matter of, they don't go to court because they don't believe in the system. There is a legitimacy issue, especially from the global north in their courts, and even more in the global north. No one from Peru will believe that a case against a German company in Germany will win. So I feel that it's not the science that is missing the piece there. It's creating the environment where people feel and believe in justice. Because at the end, the reality is we're having high hopes, but we don't have justice yet. So it's a hard sell.
Thanks. Any other one?
But
Yes,
maybe
Pilar.
if the tribunal has scientific evidence, local knowledge is not possible, don't consider scientific evidence. So it's maybe local knowledge is less strong than scientific evidence
True.
in a concrete case.
Thank you all, really interesting. My question, I think, is for Delta, the silly one. I'm trying to understand the consistency of source attribution. So if I understand correctly, the proportionate role of anthropogenic GHG emissions varies depending on the trend. So temperature increase versus sea level rise versus frequency of floods, whatever. But you also showed a slide that had the sort of top of the 19 list. It was Saudi Aramco at the top. Would it be that Saudi Aramco is most responsible for each of those trends, or does that vary?
Yeah, so you're right. So the proportionality, what changes is the physical dynamic of how those events are impacted by greenhouse gas emissions, right? So most of the cases that we see are heat, because modeling heat is the most closely tied. So events that are connected to heat are most closely tied to emissions. So scientifically, those are the strongest cases. You're going to see the same general order. That's absolutely true. It's just that those numbers are going to look a little bit different depending on the type of impact that you're looking at. And even as you see, right, so for heat, you had upwards of 50% of all heat to those 90 companies, but for sea level rise, it was only upwards of 42%, right? So there's differences there. So while you might have 3% of responsibility for a Saudi Aramco on heat, for ocean acidification, for the different events, it's going to look different. Yeah. Does that make sense?
Yes.
Okay.
Anyone in the room? Still, Ivano,
I mean, if I can.
of course.
But okay, one for Rodrigo, and then I will try to. So, Rodrigo, I really appreciate all your presentation. I just want to understand how much we can use this case that in a way is a case against a German company in a German legal system in Peru. It is something that we can really learn. And this moment, my real question is, in this moment, the legal doctrine, the legal scholarship, the judges are taking into consideration this case that, it was 2 weeks ago, the hearing, so we know that we don't even know how it's going to end in the next weeks. So it's something that is moving in Peru, considering that you are at the origin of this case, at least physically, and there is the possibility of a sort of cross-fertilization in Peru in terms of legal innovation, or do you think that?
Yeah, well, there is a saying in Peru that says no one is profiting in his own land. So
Yeah.
A lot of people know about Saul's case outside Peru, ironically. But answering that, yes, I feel that there is a point about understanding how an argument used in court in some country can be used in another court. I mean, there is not direct, specific scientific connection, but there is, especially when you talk about global circumstances or countries that people on the global south look for in the civil legal system. So if an argument, well-defined argument, is used in a court in Germany or in Spain or in Italy, judges in Peru tend to accept that argumentation. So even though there is no direct, clear connection, the reality on the ground is if everybody is accepting, then the judges are more keen to accept. That is a point of truth. So, and I feel that it's the same other way around. Like this right of nature, again, 10 years ago, it was kind of like ludicrous until some countries included into the constitution, and there have been cases that moving forward. And I just had in the BIICL event that we launched on that you invited us on London, I had a conversation with Mark, with a barrister from London. He promised his daughter to do a case to save jaguars because his daughter loves jaguars.
Yeah.
So he's like looking forward to bring some argument in the UK court about the rights of jaguars. So where is he gonna get that argument if it's not from courts from the global south? So it's a cross-pollination and it's not a direct path, but there is.
Then Marrique is a great lawyer that was also behind the Criminal case.
Yes.
So we know that, when he wants to do something, it
Exactly.
contribute to do something great.
Yes.
But yeah, anyway, it's a great, and I take advantage that I'm still speaking, so I'm asking also the other speaker a question. So I would like to understand from Delta because, for me as a lawyer, attribution science, even though I'm really trying to use as much as possible and to study, I want to understand if it's possible that attribution science can help us identify major emitters operating, for example, in a particular country like in Peru, and if we can establish the contribution to that particular country. I mean, I know that climate change is global, but
Right.
there's something like this or?
Yeah, so the closest thing that we have to that right now is that wildfire study, which is, like I said, that's the first time that we have regional downscaling. So it's the first time that instead of looking globally at how emissions, so we can, to the first part, you can take emissions from any entity. It can be a company, it can be a sector, it can be a country. Like as long as you understand what those emissions are, we can put those into the models and understand. So if it's all of the companies in one country, as long as you have that data, then we can absolutely do that. The question then is about how it traces to impacts. So the majority of the studies that are out there are looking globally. The wildfire study was the first one to look regionally, and we are looking to continue to advance that. So we have some other studies in the works to continue to look regionally. But the questions there become these data limitation questions. So it's a question of, do you have the data in that region to be able to downscale the impacts, to be able to make those connections? So I don't have a straightforward answer for you.
So regionally, but nationally is not still something that we have done.
We haven't, no. So even with the regional one that we did, it was a part of the US and Western Canada. And it has to do with the physical characteristics. So those climates were similar. So essentially we were able to use the same mathematical relationship to make that calculation. So if there is a lot of diversity within a single country, then you're going to need several different models to be able to assess that.
And sorry, Pilar, just to ask you something that I was thinking since the beginning of your presentation, because in a way I was thinking of what Michael Gerard this morning mentioned, which are these backlash cases, the slap lawsuits. And so in a way is related to the fact that we were talking about the different actors, that we had the different plaintiffs. So have you observed in a way some sort of tendency also in Chile of from the part of these companies that want in a way to avoid this kind of litigation, and so they are trying to bring suits against, for example, NGOs. We have example in France with Greenpeace against, for example, Total. In Italy, it's any that goes against, of course. Greenpeace and the others. So in a way, we see that there is this trend of companies that's trying to protect themselves by attacking for defamation these NGOs. So do you see something like this also in Chile, or is not that it's not happening yet?
Yes, a little bit. We have a case, but it's not a climate change case. It's a Dominga case. It's a mining in the sea, in the ocean, Pacific Ocean. And in this case, the company put a lot of money to talk to mal or to against the NGOs, which defend the ocean. So that exists, but it's a little bit because the environmental cases and climate change cases is related with more adaptation than mitigation. So it's a little bit different. Yeah.
But might be interesting also because when we're starting working on that with Chile, it's also interesting to understand how much, we have to be careful about that part because, corporate climate litigation, as I was saying, is also a definition, a sort of terminology that we want to use just to say that we are not talking about climate litigation against corporations just to create, two fields, but considering that they are part of the solution. But it's true also that we decided to call corporate climate litigation, the object of this study, because we know that there are the slap lawsuits and all these backlash cases. So we have to understand that they might be also the plaintiffs, and there are many cases in this moment that, especially in the US, that have been brought by the debt, so that might be, yeah. Anyway, thank you very much.
Thank you.
We're looking in the room. I have a question for each of the panelists, so maybe that'll be the last round, unless there is one more, which I'm sure we could still fit. Now let's go in. And I'm curious to sort of take some of the observations, et cetera, from, you know, we've been backward looking, kind of the progress, the developments, a lot of which is really very positive, to the world or the situation we're entering in now. And the first one is to you, Pilar. So expanding access to justice, you know, expanding the circle of those who are considered to be, whether it's individuals or public interest groups, et cetera, something that's been a decadal process in Europe. We had the Aarhus Convention, and, you know, so it's really been something that's been moving in the right direction for many years. But now we've, in recent years, and really just, I would say in the last 3-4 years, we've been increasingly hearing that actually the energy transition, the green transition, has been held up increasingly not by technology availability, technology costs, et cetera, but by the difficulty of permitting and citing any large clean energy project, infrastructure project, et cetera. And so at least in advanced, whether it's North America or Europe, there's really been a debate about rolling back some of the public participation and access to justice rights that have been created over recent decades. And so I'm curious, you know, do you observe something, since you were speaking about legal standing and access to justice in Chile, but also the other panelists, how do you see that potentially playing out, since there has been that trend? The second question is more than perhaps to Delta and Rodrigo, but again, all of you, please feel free to weigh in, and from the audience as well. So you kind of hinted, you know, it's so important to have robust emissions information. So emissions transparency in order to construct particularly the source attribution part of this equation. And there too, we're seeing a rollback, whether it is, you know, like in Europe now, Milieu Defense, you mentioned things like the Corporate Sustainability Reporting Directive. You might have seen that the EU is now having a political process to push that back, because it's seen as kind of counter to business in Europe, competitiveness of European business environment, et cetera. The SEC disclosure rule, Michael Gerard mentioned, that's most likely going to go out. So that we may be entering a world in which at the policy level, at least, the emissions transparency will be a little bit less transparent. But I also think we can safely say that in the US, at least, there's active destruction of data repositories and you know, institutions and institutional capacity that has helped us better understand emissions reporting and emissions from companies. So how do we deal with that? You know, do you see that as a real risk going forward, or do you think institutions, organizations like UCS, universities, et cetera, have enough of this data? And finally, it seemed to me like, you know, you mentioned 2017, was it Landgericht, or, you know, climate attribution science back then was a very different thing from where it is now. So it's improving so rapidly. Does that introduce, you hinted a little bit that you could also have a dynamic where almost tactically you're like, should we file now? Should we initiate lawsuit now, or will we have better data in a year or two? Will we be better able to create, you know, the causal connections? That's another thing. I'm also curious, how does this sort of progression of the scientific basis influence strategy and tactics in litigation? So, number of questions, but
so that's right. The last decade, maybe the public participation was fundamental. For example, that's allowed stop big projects in Chile. So hydroelectrics or thermal coal plants or others. So it was very, very important to define the type of economic growth. But now it's the first time I see that exists a consensus in the political context. It's not possible to open to public participation because that stops the development of the country. So it's necessary to go quickly with the investment and the project. So So it's maybe that will change or not, I don't know. But it's a critical moment to the public participation because the Congress discussed to reform the laws, the present laws concerning public participation in different areas. So yes, we will see.
So it's not just
Yes.
Europe, North America, it's
Yeah,
also in the
yes.
South.
Yeah. Yeah, so I mean, science generally is as good as the data that it has. So it's a huge thing for us to be looking at, a huge concern. And we have people on our team who actively works on disclosure specifically, because again, we need the data to be able to do the scientific assessments that we do. I think the one saving grace again is looking back to how this data was initially collected, and it was through reporting to shareholders. You know, these are the business's best interests to show their growth over time. It's those places that the data actually comes from. I think part of the concern becomes will come moving forward, will actually be different reporting methods that companies will use to share that information with their shareholders, and us being able to interpret what that actually means. So yeah, in short, it's devastating. It's really hard for there not to be strong disclosure rules, that it's necessary for us to understand the role that these companies are playing. But I think we've figured out workarounds before, and the communities will continue to do that.
Ironically, I'm gonna link both questions that I feel is very different from the red tape, from the reality. So the case in Peru, for example, they've been pushing forward to get the Espoir Accords, which is kind of like a parallel to the Aarhus Convention regarding environmental defensors and especially protecting access to justice and information. And eventually the Congress didn't accept the accord that we were pushing, because the argument that they will go against the mining industry in Peru, which is the heartbeat of the economy, in a nutshell. But the reality is, with or without the accord, with or without the law, the people will object. The people will go out. They will block. They will burn if you don't have what it's called the social license. If you don't have sustainability from a broader concept, then no matter what you do, then it's over. The biggest gold project in Peru has been blocked for 20 years. Like, they have all the licenses, all the presidents wants to do it, all the majors want to do it, but the people doesn't want to, and it's not going to happen. So no matter if you have or not, the reality is gonna build on you. And I feel it's the same with disclosure and information. There is a point about how this trend, it's pushing forward the agenda of ESG or disclosure or being green, but I feel that also it's just cleaning some bad elements. There was a lot of greenwashing in the world. There was a lot of just entities trying to just comply with the law, do any report that it was meaningless, no connection whatsoever what they do. So you have a lot of data, but not relevant data. So now it's going to become to the point that the people will say something if they mean it. And if they don't, then they will have to accept the consequences of not being completely honest or not being real, or just saying for the sake of it, just because they need to comply for some random law in the other side of the globe that they don't believe in. So I feel that it's a silver lining about the reality will mandate eventually, and circumstances will pass.
Good. I like that message. It's not a straight line, but we're still optimistic, and then we'll get in the right place. Join me in thanking our excellent panelists.